James Egan Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Mr. King, Ms. Brady, Ms. Nelson, Ms. Higgs, and Ms. Spengler. And the people are represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Mr. Edson, and Ms. Tish McGuire. The record should reflect that we are outside the presence of the jury. In terms of the people's request for an additional in-camera review of the records that were produced by the University of Colorado pursuant to PSDT and PSDT2, I conducted that review over the weekend, and I'll be issuing an order later today. Is there anything we need to take up outside the presence of the jury before we bring him in on behalf of the people?
No, Your Honor.
On behalf of the defense?
Yes, briefly, Your Honor.
Go ahead.
Your Honor, we anticipate testimony at some point this week from some crime scene investigation witnesses that we would like to move and eliminate to exclude pursuant to Rules 401, 402, 403, state and federal due process, and the Mr. Holmes' state and federal rights to a fair and reliable sentencing proceeding. First, we're anticipating that fingerprint examiner Sandra Fisher is going to be testifying either today or at some point this week, and that the prosecution is going to offer her testimony concerning fingerprinting the deceased victims and her efforts to conduct, to find matches, fingerprint matches, and to identify the deceased victims, including obtaining prints from them while their bodies were moved into the hallway or the lobby of the theater, locating exemplar prints from databases, including a military exemplar print from Mr. Larimer that Mr. McQuinn's mother had to come and identify him in person because they weren't able to locate an exemplar print for him. Our position is that all of this testimony regarding the efforts to identify, testimony that goes to identifying the deceased victims in this case should be excluded under 401, 402, 403, state and federal due process, and state and federal right to a fair and reliable sentencing proceeding, because the identity of the victims and the deceased victims in this case has already been established primarily through the testimony of Detective Matthew Ingwe, who was the witness who introduced some photographs of the deceased victims in the theater and referred to all of them, the ones who were located in the theater, by name. We've also had some testimony from first responders who encountered and tried to assist other deceased victims, Ms. Mosier-Sullivan and Ms. Gowie. And also we've had testimony from a number of witnesses who accompanied the deceased victims to the theater that night, and we anticipate even more of that testimony. So we would object to that testimony as being cumulative, as well as, it's likely to be upsetting testimony to listen to. And I just wanted to make a brief record, because I don't think we've made this record before, that we've had a number of professional witnesses, law enforcement officers, first responders, detectives who have cried during their testimony, have needed to take a moment to gain their composure, who have gotten choked up. It's difficult testimony to listen to, and we don't believe it's necessary, and we think that it would violate 401, 402, and 403, in addition to the constitutional provisions that I previously cited. I would also cite the court to People versus McClelland, which is the case that I cited to the court to previously on this issue. That case involved evidence that was introduced to establish the identity of a victim, where the identity was not disputed, and where the facts were also established by eyewitness testimony. Does the court need that cite again?
No.
And I'd also cite the court to People versus Rettig, R-E-T-T-I-G, 264 Northeast 2nd, 835. It's an Illinois Court of Appeals case from 1970, which stands for the proposition that the identity of a victim is sufficiently established where a sheriff, chief investigator, and pathologist all referred to the victim by name without objection. And I would note we didn't object to Detective Ingwe's testimony identifying the deceased victims that he encountered in the theater. Dunn versus State, D-U-N-N, 951 Southwest 2nd, 478, Texas Criminal Appeals case from 1997. Again, evidence sufficient to establish victim's identity when detective testified that victim had been identified and provided the name of the victim, as well as testimony from the victim's roommate, also identifying him as the victim. And Valdez versus State, VALDEZ, 841 Southwest 2nd, 41, Texas Court of Appeals, 1992. Also holding where a police officer who has found a murder victim testifies without objection that the deceased was a specific person, the deceased has been sufficiently identified to sustain the murder conviction. We would also object to any testimony from crime scene investigators or other individuals who measured, moved, or transported the deceased victims' bodies for the same reasons. That testimony would be cumulative of Detective Ingwe's testimony, and we would object under 401, 402, 403, and the constitutional provisions I referred to earlier. And then finally, also with respect to the any crime scene investigation testimony this week, I just wanted to follow up on a record I think Ms. Higgs previously made with the court that we are objecting going forward to any sort of setting the scene or describing the scene type testimony from these witnesses. I think we've had ample testimony of what the scene looked like when not only first responders but other law enforcement individuals arrived there, and we would object to any cumulative testimony on that point under the same legal provisions that I've previously cited.
Well, in terms of the argument that you just made related to law enforcement officers getting emotional on the stand, I haven't heard a single objection about that, so that objection is untimely.
No, we're not objecting.
Hold on, I didn't interrupt you. Please don't interrupt me. You brought it up, and you said you wanted to make a record of it. I'm just telling you, when these folks got emotional on the witness stand, nobody objected, so I can't do anything about that. That is an untimely objection. You might as well have brought it up on appeal. If you're saying that in terms of your argument as to why you're objecting to the evidence that you've outlined, then I understand. I get that. But to the extent that that was intended to be an objection to the officers getting emotional, that's untimely. There's nothing I can do about that. Now, in terms of the objection, what's the people's response? Mr. Orman?
There are a number of objections there, Your Honor. The first one was to having Ms. Fisher, a criminalist with the Aurora Police Department, testify that she identified victims through their fingerprints. I haven't heard anything in any of the cases cited by counsel that indicates that is some type of improper or inflammatory testimony. Certainly there are numerous ways in which the identity of a homicide victim can be established, and that we can do that. I haven't seen any cases that say there's exclusively one and one only that can be done. I think the jury in this case is entitled to know the procedures that the police went through to conduct their very thorough investigation at the crime scene relating to the firearms, relating to the other evidence, and relating to the victims. And the care that they took in processing the crime scene, the care that they took in identifying the victims, the care that they took in preserving evidence of the crime. I think that counsel described that as upsetting. The fact that fingerprints were taken from dead bodies is upsetting, and therefore I guess that means it's unduly prejudicial under 403. I think that's the argument. The upsetting thing is that the defendant went into a theater of innocent people and shot them. Right? The upsetting thing is the defendant shot a little girl. That's the upsetting thing. The upsetting thing is the crime. The criminalistic procedures utilized by the police to take fingerprints off of the victims, I can't see being upsetting under any stretch of the imagination. It is not like she cut off their fingers or something. She took fingerprints in a way very similar to the way you take fingerprints off of someone who is still alive. And I can't imagine how anyone finds that upsetting. I think that the objection should be overruled. Also, Ms. Fisher would testify to some other things that are beyond the scope of this, but I don't hear an objection to that. Regarding the other issues, Your Honor, I think I've discussed why we would want to present evidence as to how the crime scene was processed, and that's really what they're objecting to, is moving the bodies, how they're taken out of there, how they get to the coroner, and so forth. They're objecting to that evidence for what reason I really can't fathom. The last objection, I think, was that the crime scene people should not be able to come in and say, I went into a room and it looked like this. Apparently, they're just supposed to magically appear in the room. The jury's not supposed to have an idea of how they got there, what they saw. And frankly, Your Honor, things change over time. The jury's going to want to know what the crime scene looked like when one investigator went in there to start conducting their investigation of the crime scene, collecting evidence. They're going to want to know about the lighting. They're going to want to know if there's still anything in the air. They're going to want to know all these things. And I think that the defendant would like to set up an artificial construct where these crime scene criminalists, the other investigators, come in sort of in a vacuum, and they almost talk about like they're in a black room, and they just see an item on the floor, and nothing around them is relevant anymore, just that they see some item and collect it. Well, I think that that is disconnected from the reality of the way evidence is collected and the way evidence is presented. And I think that any objection should be overruled.
Okay, thank you. Let me start with the last one and then go backwards. In terms of testimony related to setting the scene or describing the scene, Mr. Orman is partially right and Ms. Nelson is partially right. It depends. If it's something that has already been established and testified about, then there may be a cumulative objection, and the objection has to be made timely, and then I'll rule on it. But if it's at a different time in the process, then it could be relevant. It could be something new. And so it depends on what the testimony is going to be. Is it going to be how the crime scene looked immediately after the shooting, or a little bit after the shooting, or a lot after the shooting, and why is it relevant? I'm going to have to consider those things and whether the probative value of the evidence is substantially outweighed by the danger of unfair prejudice. I have told Ms. Pearson at a bench conference that we had here, and I can't remember who defense counsel was, it may have been Ms. Spengler. I said, you've already presented a lot of, or some testimony from first responders. And so I said, unless there's something new, I'm not going to allow you to call another first responder just to repeat what's already been said or been established. And I have sustained a few objections after that on cumulative grounds or under 403, the unnecessary presentation of cumulative evidence, because I have found that that substantially outweighs the probative value of the evidence. So I told Ms. Pearson that, I'm sticking by that. But if it's related to identification or, setting the scene or describing the scene at a different point, then that may be different. Of course, it has to be relevant, and the probative value cannot be substantially outweighed by any of the dangers that are outlined in Rule 403. So I'll have to take that one on a question-by-question, objection-by-objection basis. In terms of the objection related to the measurement, movement, and transportation of deceased victims, it goes to the investigation, and so I think it is relevant. It goes to what was done in this case. It goes to what steps were taken to preserve the investigation, the integrity of the investigation, the integrity of the evidence. I think those are things that the prosecution is entitled to present, but the prosecution cannot belabor the point. You can establish that quickly with one or two questions. What was done? The deceased victim was moved, and for what reason? Something along those lines. Same thing with fingerprint evidence for purposes of identification of the deceased victims, and same thing with respect to identification, other identification evidence related to the deceased victims. This is something that can be done quickly and should be done quickly. I don't want you to belabor the point. You don't need to do that. And so if somebody wants to testify that they went through and they fingerprinted all the deceased victims, but there was one victim that they could not find matching prints for, and so a relative had to come and identify the deceased victim personally, then you can establish it that briefly. It isn't something that should be gone into in much more detail than that. Again, the point is allowing the prosecution to present its evidence and to show the jury what the investigation was like, how the integrity of the investigation and the crime scene was preserved. those kinds of things, and not to make it so that it is drawing on the jury's sympathy in any way. So those are the guidelines that I will set. Again, you'll have to object if you think that there's a question that is objectionable, and I will rule on it at the time of the objection. So, and then in terms of the cases that were cited by Ms. Nelson, I appreciate the cases. It sounds like these were cases, the ones from outside jurisdictions I'm talking about. It sounds like these were cases that dealt with what evidence is sufficient to establish the identity of a deceased victim, as opposed to the issue that's before me, which is should the court sustain an objection under Rule 403 for danger of unfair prejudice when the identity of a deceased victim has either already been established through other means or can be established through other means, which the defense believes is less prejudicial. So I don't, it doesn't sound to me like those cases are on point, although I haven't read them. But it sounds like those cases were merely going to the point of what is sufficient to establish the identity of the victims. All right, before we bring the jury in, would counsel for each side please approach? Just one attorney per side. All right, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury has joined us again. Good morning, folks. Good morning. I hope you had a good winter this weekend. We're back to spring today, and then I hear we may get to summer later in the week, and then back to spring again. Thanks for coming back, and thanks for being on time. At the end of the week, last week, the prosecution had called a witness by the name of Christopher Dean Rigopoulos. And Mr. Rigopoulos is back on the witness stand at this time so that the prosecution may resume its direct examination of him. And sir, I will remind you that you're still under oath, okay? You may have a seat. Thank you. All right, Mr. Orman, you may proceed with the rest of your direct examination.
Thank you, Your Honor. Sir, when we broke off for the weekend, we were discussing your qualifications, and I want to spend some more time on that. I want to talk first about training that you have participated in. I guess I would call it sort of advanced training in your field. Have you participated in both receiving and giving training in that area?
Yes, I have.
All right, let's talk about the specific trainings that you have received relating to explosive and incendiary device analysis and things of that nature. What has that been?
There's been several things that I've undertaken. Example, I attended the improvised explosive device course in Kyneton, England, provided by the British Army,
I think you're going to have to spell the name of that place for us.
Kineton.
How long was that class?
It was approximately 3 weeks.
Okay, and anything else in England?
I also attended Scotland Yard's bomb management course.
How long was that class?
That was also 3 weeks.
And Scotland Yard would sort of, what is Scotland Yard?
Scotland Yard is an old term for the Metropolitan Police, which serves London and in the area. That's their law enforcement branch.
How about training people in the United States and other countries in this area? Can you tell us about that?
Yeah, I am, for the FBI, I'm the post-blast investigator course program manager. I manage the schools that the FBI presents to our domestic partners as well as our foreign partners.
Have you trained examiners from other countries?
Yes.
What countries?
Other countries, England, Ireland, Australia, Jordan, Yemen, Greece, Turkey. Also had some from Lebanon and Qatar, Bahrain, Egypt, India, several others can't recall, but there's a lot.
I think we get the point there. I want to ask you about some specific cases or incidents that you've worked on, and if you could tell me whether or not these have provided you with information and experience that has assisted you in doing your job as a explosives and hazardous device examiner. 1998, bombing of the United States Embassy in Kenya. What did you do there, and if you could tell us what information you sort of experienced, you learned from that?
The bombing in '98 was a large vehicle bomb that targeted our U.S. Embassy in Nairobi, Kenya. And I was part of the evidence response team that responded to that scene to conduct a post-blast investigation. The scene was tremendous. The perimeter was really large, and there were multiple casualties, hundreds.
I'm going to object to the descriptive testimony.
Sustained.
Can you tell us what, without going through what you did there, what areas you covered and what type of information you were able to obtain through doing that?
Primarily evidence collection from the bombing scene, identifying parts from a post-blast scene that were part of the bomb, and being able to recognize and separate those parts from other evidence that might have been affected by the blast, and submitting it, packaging it for further exploitation in our FBI laboratory.
The 1999 Egypt Air Flight 900, did the FBI ask you to participate in that investigation?
Yes, I did.
And did you?
I did.
September 2001, the terrorist attack on the World Trade Center in New York City, did you go and respond to that as well?
I did.
And without getting into exactly what you did, what type of experience did you receive from doing that assists you in your analysis?
Tremendously large
Then I'm
scene.
going to object. It doesn't go to any material issue in our case. There was no explosion in our case. I'd ask that the qualifications of this witness be limited to the scope of the expertise for this particular case.
Overruled. It goes to his expertise in the area in which I anticipate the people will attempt to qualify him in. So the objection is overruled.
So you were saying that, would it be fair to say that assisted you in learning how to deal with an extremely large crime scene?
Yes, sir. Extremely large crime scene and tremendous amounts of evidence, as well as working with other agencies as far as cooperating and collaborating in our evidence collection and investigation.
2003 through 2005, various locations in Afghanistan and Iraq. Can you tell us if through doing that you were able to learn anything about booby traps and the way that improvised explosive devices are designed and used?
Yes, absolutely.
And I don't need you to get into exactly what you did there, but through that time period in Afghanistan and Iraq, about how many improvised explosive devices do you think you were able to encounter?
As far as response as well as evidence that was turned into us, I ship back to our FBI laboratory approximately 1,200 different submissions. Those are different IEDs or multiple IEDs.
Fair to say you learned a lot about how to analyze IEDs?
Yes, sir.
Section leading.
Overruled. It's a follow-up. You may answer.
Yes, absolutely.
2007, Banja Luka in Bosnia-Herzegovina. Can you tell us what experience and expertise in what areas that might have helped you and what that was?
That was a singular attack, a bombing attack, where someone was targeted.
Judge, I'm going to note the same objection I made to this earlier.
Sustained. So you can talk about what you did that assists in your expertise, but not about any of the details.
Yes, sir.
Okay? All right. You may proceed.
So why don't you tell us about what you did that assists in your expertise?
In that case, the detailed evidence collection from an IED that exploded and the detailed time that it would take in this case, a controlled environment, to be able to recover the evidence to assist the police department we were tasked assigned with to further their investigation.
And 2010, Stockholm, Sweden, again, if you could tell us what you learned there that assists you in, and what tasks you conducted that assists you in your job now as a firearm explosives and hazardous device examiner.
The Stockholm, Sweden bombing, identifying the tactics, techniques, and procedures that the bomber utilized, the evidence that we collected in this scene, identifying the different type of components that the bomber chose to use when he built the IED, as well as how he engineered it into the design of the IED, recognizing how it would function, how it would work, and the evidence crime scene was very small, so it was very efficient to be able to collect everything. Taking that information and interpreting it into a forensic report to assist the Swedish government.
2012, Beirut, Lebanon. Same question, and please limit it to the same type of answer.
Similar in scope to the Stockholm, Sweden, where is a large scene where we would effectively collect evidence from a vehicle bomb, and this evidence would tie it into the design of the IED, recognizing how it would function, how the design of the bomb was placed, and how it would work and influence the area around it. Those are things that we're observing and documenting and collecting as data to help with our understanding of how the bomb was designed, what it was supposed to do.
2013, Athens, Greece, same question, and please limit it accordingly.
In this case, a bombing involving a pressure cooker and identifying the type of components that were utilized in this and how it would function. Once again, comes down to the design, understanding how it would work, and being able to relay that information to our law enforcement counterparts in Greece.
And lastly, 2013, Ankara, Turkey. Can you explain, same question?
In this case, our U.S. Embassy was attacked by a suicide bomber, and the evidence was contained basically within our compound. So it's evidence collection and being able to understand the components that the bombers used in their design and how they attempted to influence the area and affect injuries on the people around them, and understanding the components, where they may have come from, how they built it, potentially where they built their devices, and relaying that information once again in a forensic report.
Now, you work for the FBI. Where would we find people with equivalent expertise around the world? What agencies would they work for?
Objection, Your Honor. Relevance.
Overruled.
You can answer.
So, in my experience, we have a wide variety of investigators and partnerships and relationships that we have across the board. With people with similar experiences, are the ones I have experience with, would be similar like Scotland Yard, the Australian Federal Police. We've worked many scenes and cases together. And there are other countries that have multiple bombings we've assisted with, which are, I have not as much experience with them, but there's a lot of talent out there.
Have you ever testified as an expert witness in the field of explosive and hazardous devices?
Yes, I have.
How many times?
3 times prior.
What courts?
One court was in Alaska,
Is that a federal or state court?
federal.
Okay.
There's a court in Tucson, Arizona, federal court, as well as one on Long Island, New York, as also federal court.
Your Honor, I would ask that the court accept this witness as an expert witness in the field of explosive and hazardous devices.
Any additional objection, Ms. Spengler?
No.
Without any additional objection, and based on my previous ruling and the record made here today, the court finds that Mr. Rigopoulos, Special Agent Rigopoulos, is qualified to offer expert opinions in the field of explosives and hazardous devices, and so he may testify and offer expert opinions in that field. That ruling is pursuant to Rule 702 of the Colorado Rules of Evidence, and the decision in People versus Shrek, 22 Pacific 3rd, 68, Colorado 2001. Members of the jury, you are not bound by the testimony of a witness who testifies as an expert. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it or none of it. The weight that you give the testimony is entirely your decision. All right. Mr. Orman, you may proceed.
Thank you. Were you part of the explosives and evidence collection response to the defendant's apartment located at 1690 Parish Street, number 10?
Yes, I was.
When did you get there?
We got there on the Friday evening into Colorado.
So the late evening of the 20th?
That's when we got to Colorado, got to the scene the morning of the 21st.
Okay. Now, we've seen photographs of the defendant's apartment and some video, and I'm going to ask you some questions about that. But before I do, I want to ask you some general questions. First, as an expert in the field of explosive and hazardous devices, do you form and talk about opinions as to whether items are in fact explosive or incendiary devices?
Yes, I do.
Do you form and express opinions as to how such items are designed to work?
Yes, I do.
Now, I want to discuss the information that you rely upon in forming your opinions. Did you have an opportunity to actually see the items that were inside and removed from the defendant's apartment?
Yes, I did.
Did you have an opportunity to see the components of those items
I did.
at the scene?
Yes.
And were you involved in things like taking samples from those items and collecting them as evidence?
Yes, I did.
Did you take your observations at the scene into account when you reached your opinions in this case?
Yes, they were valuable observations.
Do you work as part of a larger lab?
Yes, I do.
What is that lab?
It's the FBI lab. It's located in Quantico, Virginia.
And do people in your lab conduct analyses into things like chemistry, electronics, metallurgy, and things like that?
They do.
And do you take that information into account when you express your opinions?
I do.
And is that the type of information that is normally relied upon by experts in your field of expertise?
Yes, it is.
And did you rely upon that information in your opinions in this case?
I did.
Now, do you have an opinion as to whether that apartment contained explosive devices?
Yes, I did.
What is that opinion?
It did contain explosive devices.
Do you have an opinion as to whether that apartment contained incendiary devices?
Yes, I do.
What is that opinion?
The apartment did contain incendiary devices.
Now, before we get into that in great detail, I want to ask you about some other actions that you took in the apartment, specifically with regard to the collection of evidence. And I think that you testified that you've been involved in numerous instances previously where you've collected evidence. Is this part of your job to assist collecting evidence?
Yes, it is.
So I want to talk about the various stages of what you did there in the apartment and what your role was. So first of all, I want to talk about the early part of Saturday, the 21st of July. Can you tell us what your role was when you first arrived there?
Yes. When our team arrived from Quantico, Virginia, we were dispatched to assist on the scene. We arrived, myself and I have a counterpart from our counter IED unit. He's also a special agent bomb technician. His role is on the pre-blast side. My role is more on the post-blast side, as I described earlier. So we were there as consultants to the bomb technicians on the scene as they're formulating their plan to render safe the problem at hand, and as they've evaluated it for the day and a half.
Okay, so I want to talk about the actual, were you involved then in the actual render safe procedures?
In a peripheral manner.
And just in general, in your opinion, what does render safe mean?
Render safe it's a operation where you're making the bomb in a condition where it will not function. And then it can be collected as general evidence.
So is the idea to get it to go off or the opposite?
The opposite.
And do bomb techs and people in your field train not to set the stuff off?
That's correct.
Do you recall how long it took for that render safe operation to be completed?
The render safe operation started pretty much when the sun came up Saturday morning. I want to say around 6 a.m. And it went to approximately 4:35 p.m. that afternoon.
Now, while the render safe procedures were being carried out, were you involved in collecting evidence?
Yes, I was.
And then were you later part of a different team collecting evidence subsequent to that?
Yes, I was.
All right, I want to talk to you about your role in collecting evidence as the render safe procedures were undergoing. Can you describe how that worked?
As the render safe procedure was being enacted, the bomb technicians were going through different stages of disassembly of this device. And in these stages, it was my request for them, as they got to a certain point, if they could bring down samples of these of the chemicals or the powders that they encountered, so we could start recovering them as evidence. But since there was so much material that was there, a lot of it was in a dangerous condition, they may have to destroy it for safety reasons. But I wanted to be sure we took samples, if possible, prior to that destruction.
And did you also collect physical examples as well?
Yes, we did.
Did you collect some of those spheres that we've seen?
Yes, we did.
Fusing
Yes.
and gasoline, things like that?
Yes, that's correct.
And while you were doing that and were you the team leader then of this portion of the search?
For the evidence collection part, the sampling part, yes.
And did you oversee it?
Yes, I did.
Did your team that was doing that take photographs of the items then that were collected during the render safe procedure?
The photographs were taken inside as well as outside.
And have you seen those photographs?
Yes, I have.
Your Honor, if I may approach the witness with what I've marked for identification as People's Exhibits 4015 through 4058.
Yes, you may.
I'm sorry, it's 4048. I misspoke, Your Honor.
Okay, so it's 4015 through 4048.
Why don't you take a quick look at those for me, please? Yes. Oh, thank you. Have you taken a look at those?
Yes, I have.
Do those accurately depict the evidence items that were collected as part of your evidence collection during the render safe procedures?
Yes, they do.
Your Honor, I move to admit.
Any objection, Ms. Spengler?
Yes, Your Honor, I object to several of the photographs as cumulative to physical evidence and photographs the jury has already received and has already been admitted into evidence, if I may approach to identify those.
Sure, or you can just identify them by number if you want from counsel's table. If you want to make further argument, you can approach, or if you're just going to identify them, you can identify them from counsel's table.
Okay. 4018 is cumulative to physical item evidence 898, which is the cooler. Same with 4019, also a picture of the cooler. It's been admitted as evidence, and there's another photograph, 4017, that we do not object to that also shows the condition of the cooler. 4020 is also cumulative. Do not object to 4021. 4022 and 4023 is cumulative to 4021, as well as the glycerin bottle that was received into evidence at 899. 4030 is cumulative, as is 4029. And without further information, 4036, 4039, 4040 is cumulative, and 4041 and 4042 is cumulative to 4043. So,
Is your argument that 4036, 4039, and 4040 are cumulative of each other? Is that what you said?
they could be cumulative of each other. Without additional foundation, it's difficult to know. They're all identified as a dark color.
They all have different exhibit numbers on them. They're separate samples collected, Your Honor.
All right, could I see those pictures, please? Thank you. Why don't counsel approach, please? All of the objections are overruled pursuant to Rule 403 of the Colorado Rules of Evidence. Here you go, sir. Thank you. I may have put some of those out of order. I'm sorry. All right. You may proceed, Mr. Orman, over objection. People's Exhibits P-TR-4015 through 4048 inclusive are all admitted and may be published.
Thank you. Did you take samples from the frying pan
Yes, we did.
and from the glycerin bottle
Yes, we did.
and from any of the spheres?
Yes, we did.
What samples did you take from the spheres?
There was a black powder sample that was recovered.
And how about samples from, there were some half spheres on top of those pickle jars. Did you take a sample of that?
Yes, we did.
And then there was like a mortar and pestle in the middle. Take a sample of that.
Yes, we did.
Objection to the form of the question, counsel's testifying.
Overruled?
Did you take a sample of now those the liquid that was in those soda bottles?
Yes, we did.
I want to go on to more evidence collection. After you collected all of the sort of explosive stuff from the render safe operation, did you turn over the scene to someone else? Or turn over the evidence collection to someone else?
The evidence collection was suspended until another search commenced,
All right. When did that start?
after 5 p.m., I believe.
Were you part of that?
Yes, I was.
And who was in charge of that search?
Special Agent Leslie Copper of the Denver FBI field office.
What was the purpose of that search?
That search was the general evidence collection from all the items from the apartment, for the case investigation.
And did you see all the items in the apartment?
Yes, I did.
And did you participate in that evidence collection?
Yes.
So if I showed you photographs of the evidence as it was in the apartment, would you be able to identify that as, yes, that was an item in the apartment that was collected?
Yes, I could.
Now, I'd like to talk about the way that the FBI documents this. Do they take photographs of the evidence as it is in the apartment?
Yes, I do.
Now, first, do they go in and take any photographs before the evidence is collected?
Yes, I do.
And what's the purpose of that?
We call those overall photographs to get the condition of the search area prior to the evidence being picked up.
Now, we've previously seen some photographs from Shane Heater that showed the apartment with the...
I'm going to object to the counsel's form of the question. He's testifying.
I haven't even finished the question yet, Your Honor.
Yeah, hold on. Wait till he finishes. Go ahead.
Now, we've previously seen some photographs from Sergeant Heater that have shown evidence, explosive items in the apartment. Would the overall photographs taken by the FBI evidence response team be different than those?
Yes, they would.
Why is that?
The photographs that bomb technician Hyder took were taken as the render safe procedure was going on, as they were dismantling the device and separating the dangerous items.
So would things be out of the apartment then that would not be shown in the later photographs taken by the evidence response team?
Yes.
And then after the evidence is collected and everything is taken out of the apartment, are any more photographs taken?
Yes.
What's the purpose of that?
To show, once again, the condition of the area to be searched prior to the evidence collection actually commencing.
Well, I mean after it's done. I'm talking about at the end, after all the evidence is collected.
Typically, once the scene is finished, we do what we call exit photographs, which show the condition of the location searched after the search is completed.
Now, for particular pieces of evidence, let's say it's evidence item number 1 or something like that, can you describe the process of photographing that evidence and what is captured?
We would photograph the item and name what we were calling it, and it would be documented.
Well, would there be a photograph taken with a number and without a number is what I mean?
That's the preferred method, with what we call a number tent next to the item, so the evidence item can be easily related to our photographs, because we try to have all of our papers cross-reference with each other. The evidence item on a photograph can be seen on the evidence collection log.
I'm going to show you some photographs, Your Honor, if I may.
Okay.
Your Honor, this is going to be 2315 through 2509, not including three of them, 2335, 2336, and 2446. Additionally, there's a second sequence of 3953 through 4012. Why don't you take a look at those and let me know when you're done so I don't just stand here.
Okay, sir, all set?
Now, does that set include the types of photographs you normally expect in an FBI evidence response team collection?
They are.
Does it include the overall photographs before you collected the evidence?
Yes, they do.
Does it include the overall photographs after your team collected the evidence?
Yes, they do.
And does it show photographs of the items of evidence collected, or at least most of them, with and without that little designator with the number?
Yes, I do.
Your Honor, I move to admit.
Is there any objection, Ms. Spengler, to People's Exhibits 2315 through 2509, with the exception of 2335, 2336, and 2446, as well as People's Exhibits 3953 through 4012?
No objection.
All right, without objection, P-TR-2315 through 2509, with the exception of 2335, 2336, and 2446, are admitted and may be published. Similarly, P-TR-3953 through 4012 are admitted and may be published.
I just want to jump ahead for a second here. We're going to get to items of evidence you collected in a minute. But I want to talk about your role after all the items were collected. Can you tell us, so after everything was collected out of the apartment, or at least all of the FBI items were collected out of the apartment, what was the procedure for getting those items to your lab?
In this case, as I was part of the search and on scene as a laboratory advisor, I personally took custody of the items, and on our FBI plane, we flew them back from Aurora back to Quantico, Virginia, where we would further process the evidence in our lab.
So you literally flew with it back to Quantico.
Yes, I did.
Can you tell us about what you did then at the lab? So you've taken this stuff personally from Colorado to Virginia. What do you do with it when you get it to Virginia?
In the explosives unit, which is my unit, we would take evidence like this into our check-in room, and we would literally check it in, which we do conduct an inventory, and we would make sure the inventory that we had matches what we had on our list from when we left, and we're also giving it a laboratory number for this submission. And each individual item would be given a special laboratory identifier for each piece of evidence.
Let's talk about that for a second. What is that identifier?
Well, we call them Q numbers, like the letter Q, and it would have a number following the letter. And those are question items, items that we're going to examine.
How are those Q numbers designated?
We assign the numbers at that point in the check-in process.
When you look at the photographs from the group of photographs where you were overseeing everything, and then the group of photographs where you participated, but Agent Copper was overseeing everything, some of the numbers overlap, like you might have two different number ones from the evidence collection. Why is that?
Those would have been two separate searches. So there might be a search earlier in the day before Special Agent Copper's team began theirs. That search began and ceased. Then the next search took place where her team started from one to, carrying on through the different numbers.
When you got it to the lab and assigned it this Q number, are those duplicated?
No, they're not.
So even though it might be number one on yours and number one on Ms. Copper's list, would it have a different Q number?
It would have a different Q number, as well as each individual evidence item would have a reference to what the original number was at the field office.
Now, does your team then do all of this at the crime lab in Quantico?
Yes, we do.
And did you oversee this?
I did.
And did you see all the steps of it?
I managed it, yes.
And you were in the room?
Yes, I was.
Okay. And as part of that, does the lab take a photograph of the item as it looks when it enters the lab?
Yes, we do.
And do you also, with that photograph, include the Q number, so if an item wants to be referenced by Q number, you can figure that out by looking at the photograph?
Yes, we do.
Also, when evidence is packaged after this, does a Q number go on it?
Yes, it does.
So if someone wanted to look at a package of evidence that had a Q number on it written by the FBI, and they wanted to know what it originally looked like at the time it entered the lab, would there be a photograph available to show that?
Yes.
And have you seen those photographs?
Yes, I have.
May I approach the witness with what I've marked for identification as People's Exhibits 4305 through 4507?
Yes.
Why don't you take a gander at that for me and let me know when you're done?
Okay, sir.
Do those photographs accurately show the way that those items looked when they were processed into your lab?
Yes, they do.
And do they also show the Q number reference that your lab assigned to it?
Yes, they do.
So if I were to ask someone, well, you looked at Q number so-and-so, would we be able to look at that and know exactly what it looked like?
Yes, they should.
Move to admit, Your Honor.
All right, any objection, Ms. Spengler, to People's Exhibits 4305 through 4507?
No objection.
Without objection, P-TR-4305 through 4507 inclusive are admitted and may be published.
Thank you, Your Honor. And I'm going to do that as we talk about particular pieces of evidence. I want to now ask you about collecting evidence. So you've talked about how your team collected stuff during the render safe. You've talked about how you were part of Leslie Copper's team to collect evidence from the apartment. Now, I want to ask you, where did you collect evidence in the apartment?
The area I collected was in his bedroom,
The defendant's bedroom?
and his bedroom. That's correct.
Were you working with other people?
Yes, I was.
And did you observe other people collecting evidence
Did.
too? You got to wait for me to finish the question, even if you know where you think I'm going, so she can take it down easier. Let's take a look at some items of evidence. If I can have 919 and 920, please. Jeremy. All right, how about this? Just hand me what's on top, and we'll just do it that way. Your Honor, may I approach the witness?
Yes.
And I'm going to be doing this multiple times. Can I just do it without asking?
Yes.
Thank you. I've handed you what's been marked as 376 and 953, I believe. Is that correct?
Yes.
Okay,
Yes.
What's that first one?
$953?
Sure, what's $953?
It's a box that would contain a shotgun.
I'm sorry.
A box that would contain a shotgun?
And like what you would buy a shotgun in?
Yes, it would, yes.
Where did you find that in the apartment?
I did.
Where?
That was found in his closet in the bathroom.
And what's the other one?
The other is item 376.
What is 376?
376 is an ammunition box.
Now, did you observe that in the apartment?
Yes, I did.
And did you observe it being collected?
Yes, I did.
And now your name is not on there as the collector. What was your role in that?
I observed the collector.
And then did you observe it put in the bag, and did you take it then to the lab and so forth?
That's correct.
Your Honor, I move to admit both of those exhibits, 953 and 376.
Any objection?
No objection.
All right, without objection, P-TR-376 and 953 are both admitted.
Can we please put up People's Exhibit 2387? What is that?
That's the box the shotgun would have been in.
Okay, if we could please take a look at 2388. and 2389. Now, it has a little 17 on that. What does that mean?
That's the item number that it was collected for our log.
And where was this found?
This is in the bathroom closet.
And 4382, please. What is this showing?
It shows the box that we collected with a scale.
And now, on all these numbers with FBI lab, there's a Q number, and then ABR. What does that mean?
In the FBI laboratory, all the different examiners have what we call symbol numbers once you become a qualified examiner. And ABR are the symbol numbers that are assigned to me personally.
All right, I'm going to now show you what I've marked as 919 and 920. What are 919 and 920?
919 and 920, they are pistol cases, plastic boxes.
Did you find those in the defendant's apartment?
I did.
Where?
I found these in his drawer, the defendant's drawer in his bedroom.
Move to omit 919 and 920.
Any objection?
Objection.
Without objection, P-DR-919 and 920 are admitted.
If I could please display 2411. What is that showing us?
It's a photograph depicting where I recovered these pistol boxes from.
Where is that in the bedroom?
This is in the defendant's bedroom, in his nightstand, in the top drawer.
And then off to the right, what is that item on the floor?
On the right is the ammo can I described earlier.
Okay. I'm going to approach now, Your Honor, with People's Exhibit 921. What is that?
This is a wall calendar.
Where'd you find that?
I found this on the wall of the defendant's bedroom.
Move to omit 921, Your Honor.
Any objection?
No additional objection.
Without any additional objection, and based on my previous ruling, P-DR-921 is admitted.
If we could please show 2408. What does that show?
That's a photograph depicting the calendar I just described hanging on the wall of the defendant's bedroom.
Now, one thing I noticed on the closet, there's this yellow thing with the letter I on it. Was that in there originally, or is that something you guys put in there?
That is something that the evidence response team members did to designate a different room or location that's being searched.
So what would room I be?
Room I in this instance is the closet.
If we could please put up 4395. What is that showing?
That's a photograph depicting the calendar as taken in our laboratory.
Now, there's a symbol on a particular date. What date is that?
That is the 20th of July, 2012.
And so the record is clear. Can you describe what that symbol looks like?
It's evident for the jury. They can take what they want. It would be an improper characterization.
Well, he can describe it, but I will remind the jury that it's up to you to figure out what is depicted on there. You're not bound by this testimony. This is just his observation. Go ahead.
What I observed on the 20th, it's a circle with the number 1 inside of it. And then there's, we call it an infinity symbol that goes laterally within the circle.
Thank you. If I could please have 922. What is 922?
922, it's a box that would contain ammunition.
Where did you collect that?
This is collected in the defendant's bedroom on the floor.
Do you remember what type of ammunition?
This is small arms ammunition,
What's a small arm?
like a handgun.
Could we please put up 2406? Your Honor, I move to admit 922.
Any objection?
No objection.
Without objection, P-TR-922 is admitted.
Could we please put up 2406? And what is that?
This is a photograph depicting the box in question as we found it in the defendant's bedroom.
And 4393, please. And what is that?
That's the same box in question, photographed in our FBI laboratory in Virginia.
Okay, if I could have the next thing, which I believe is a joint exhibit of a number of things put together. If we could please put up, actually, never mind on that. I'm going to hand you what I've marked for identification as People's Exhibit 933, 934, 935, and 936. Can you tell me what those are?
There's multiple items in this packet, including a U.S. passport.
Well, that's 933, right?
That's correct.
What's 934? Would that be a gun cleaning kit?
934 is a gun cleaning kit.
What's 935?
935, it's miscellaneous ammunition that would go with a rifle.
And 936?
936 includes 2 handcuff keys.
Where did you find those items?
Recovered these items out of the defendant's dresser in his bedroom.
Your Honor, move to about 933, 934, 935, and 936.
Any objection?
No objection.
With that objection, P-TR-933, 934, 935, and 936 are all admitted.
If we could please put up 4322. What's that showing?
A photograph taken in our laboratory of the defendant's passport.
I'm sorry, if we can show 4325, please. What's that?
A photograph taken in our laboratory of the gun cleaning kit.
4326. What's that?
Photograph taken in a laboratory of miscellaneous rifle ammunition.
And this was found in his dresser.
That's correct.
And 4327.
This is a photograph of the 2 handcuff keys taken in our laboratory.
Sir, I'm going to show you another group of items, 937, 938, 939, 940, 941, 942, 943, 946, 947, and 948. And I'm going to also show 945. Would it be fair to say this is a group of items taken from the same spot?
These items, I believe, were recovered from the defendant's dresser, as were the nightstand.
Okay, can we please put up Exhibit 3957. What is this showing?
This shows the items that I'm holding in situation, in the location where we recovered them in the defendant's bedroom.
Move to admit, Your Honor.
Any objection?
No objection.
Without objection, P-TR- 937, 938, 939, 940, 941, 942, 943, 945, 946, 947, and 948 are admitted.
Thank
Did
you.
you get those right, Mr. Orban?
Yes, I think so, Your Honor. I want to show you some pictures and just ask about these so we can see them. Can we please put up 4488? What is that?
That's an instruction manual for a Smith & Wesson rifle.
And that was found in the location you just described?
Yes, it was.
All right, if we can go to the next one, which is 4489. What is that?
This
This is the manual that was found in the same location about a drop holster.
4490. 4491. What are we looking at there?
This is a small book which describes the rifle sighting system. It's like a vise.
Now, even though you didn't collect it, did you observe something like that in the apartment?
I did.
Do you remember where it was?
It was in the bedroom.
Next is 92, please, 4492. What is that?
This is a book that was recovered.
And what's it about?
As you see from the title, from the front lines to the hunt of a lifetime, the industry guide to proper care and cleaning of firearms. It's pretty much how to clean a gun.
93, please. 4493. What are we looking at there?
These are instructions on how a trigger lock functions.
4494. What is that?
This photograph is depicting an owner's manual for the shotgun that was in the Remington box.
4495. What is that?
This is a document used for the maintenance of like a gas mask.
Okay. 4496. What are we looking at there?
This is the handbook for how the Glock pistol would function.
4497. What is that?
This is a box and some peripheral items for a red dot sighting kit.
4498. What is that?
This is like a type of receipt from Bass Pro Shops for receiving a weapon.
4499. Now it's a little, can you read that? Because it's a little washed out on this picture.
That's a Bass Pro Shops receipt for the purchase of, I believe it's for the shotgun.
Does it indicate a cost?
I believe it's $389.
Okay, if we can go to 4501, please. What is that?
This is a sale receipt from Gander Mountain for a firearm.
And 4502, please. What is that?
This is the cash register receipt for the same for the firearm in the previous picture.
Okay, and if we could go now to 4503, please. What is this?
This is a business card that was recovered in the defendant's dresser.
And 4504. What is that?
This is a photograph of the same business card from the defendant's dresser, but this is the other side of the card.
4505. What is this?
This is another receipt that's unsigned for a firearm sale.
And 4506. What is this?
Another cash register receipt for a firearm.
And what kind of firearm?
This is for a Glock 22,
Can you
a pistol.
Can you tell the date on that?
Appears to be May 22nd, 2012.
And last in this series, 4507. Thank you. If we could please put up photograph 2505. What is that?
That's a pair of Levi's blue jeans.
And did you collect anything from the pocket?
Yes, I did.
What is that visible there, sticking out of the pocket?
Yes, it is.
And let's go to photograph 2416. What is that showing?
This is a photograph of a metal ammo can in the defendant's bedroom.
Did you collect that?
Yes, we did.
I'm going to approach Your Honor with People's Exhibits 949 and 950.
Okay?
What's a 949?
949 is that index card in a picture that was inside the pocket of the blue jeans.
Can we please put up photograph 4485? Actually, yeah, 4485. Is that the index card?
Yes, it is.
Move to admit 949, Your Honor.
Any objection?
Objection.
Without objection, it is admitted. That's P-TR-949.
And 950, where'd you collect that from?
That was from the defendant's bedroom floor.
Move to admit 950.
Any objection?
Objection.
Without
And-
objection, P-TR-950 is admitted.
If we could please put up 2417. And again, does that show that with the evidence flag in there?
Yes, it does.
If we could, if I could please have 951 and 952. Can you please tell me what 951 is? I'm sorry, 951.
951, it's a quantity of shotgun shells.
Did you collect that in the defendant's apartment?
Yes, I did.
Where?
It was in the defendant's floor.
Can we please put up 2414? I must have written it down wrong. How about 2404? What is that?
That's a photograph depicting these shotgun shells in situ in the bedroom of the defendant.
Move to admit 951, Your Honor.
Any objection?
No objection.
Without objection, P-TR-951 is admitted.
And what is 952?
952, it's a quantity of shotgun shells.
And there's a box associated with that. Is that the same box that it came in?
Yes, it is.
Is there like a name on the box or anything like that?
The name is Remington.
Okay, is there like a shipping label or anything like that on that box? Apparently not. Okay. Your Honor, move to omit 952.
Any objection?
No objection.
Without objection, P-TR-952 is admitted. Mr. Orman, would this be a good time to take our morning break, or are you almost at the end of your direct examination?
Well, I think I have one or two items of physical evidence, and that might be, and when we're done with that, that might be a good time to do it.
Okay, let's do that.
Thank you. I'm going to approach with 377, Your Honor.
Okay.
What is that?
377, it's a quantity of targets.
And where were they collected from?
They're collected from the defendant's bedroom on the floor under the window.
Did you observe those collected?
I did.
And then did you take them to Quantico?
Yes, I did.
And were those actually are those the targets you saw collected and then you took to Quantico from the defendant's bedroom?
Yes, they are.
Move to admit, Your Honor.
Any objection?
No objection.
Without objection, P-TR-377 is admitted.
And, Your Honor, what I'd ask to do just very briefly is have Special Agent Rogopoulos stand up and show the individual targets so the jury can see them.
All right? you
It's
may
very
do that.
heavy. I don't want to pass it around necessarily. Can I assist, Your Honor?
Yes.
This is a good time for a break, Your Honor, I think.
All right. Okay, members of the jury, let's go ahead and take our morning break. Let's take the usual 20 minutes, okay? Please keep in mind that all my admonishments apply during the break. Have a good break. The record should reflect that the jury has exited the courtroom now. Counsel, I'll see you back here in 20 minutes. The court will be in recess.
Do you want me to move that to the evidence table, Your Honor?
Please.
Okay.
Thank you. The court is in recess.